case briefs, and so much more. LSData's got what you're looking for.
In 1884, the Supreme Court of California heard the case in Estate of Billings, which revolved around the question of whether a partially dated document could be considered a valid holographic will. Under Section 1277 of the Civil Code, for a document to be a valid holographic will, it must be entirely written, dated, and signed by the person making the will. The case arose when a handwritten document by the deceased was found with the words April 1st written on it. The issue at hand was whether this document could be considered a valid will, since the date was only partially written by the deceased, with the remainder printed on the letterhead. This raised questions about whether the document met the criteria specified in the statute that mandated it to be entirely written, dated, and signed by the testator. Ultimately, the court determined that the document did not meet the requirements for a valid holographic will, as it was not fully written, signed, and dated by the deceased. Citing Section 1277 of the Civil Code, the court upheld the lower court's ruling that the paper could not be considered a valid will under the law.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind, leave the stress of class.